Remember bump stocks? Pepperidge Farms remembers. And if you're like me, you probably didn't really see much of a point. But I do now, which has to do with the regulation and the laws about when can the ATF criminalize something, when can the executive branch, in essence, criminalize something, and when does that have to come through Congress, and what does that all mean in a post-Heller and BRUEN world? We have a new decision that has dropped, Cargill v. Garland, on January 6th of 2023. We're going to briefly go through that and explain why it's important and what you need to know next. So guys, really quickly before we get into this, I know that close to 90% of you who watch this channel are actually not subscribers. It really does a lot for us to have subscribers. Of course, people clicking like to show their support, not only for us, but for the Second Amendment as well, to help this channel grow. So that's going to be the only plug I'm going to do until the end. So please take a moment, subscribe, click the notification bell so you can see when new videos come out, as well as to click like on this video, and of course, share around with your friends. And again, thank you very much from all of us here. So let's get into this. So let's start off by doing a quick review, just to make sure that we can see how we got here, because that is going to be important for the case. It all started, of course, October 1st of 2017, which was the Las Vegas shooting, where there were 60 people murdered and hundreds more injured by a lunatic. This, of course, was a nuclear firestorm, politically speaking, and bump stocks basically were targeted from people on both sides of the aisle. The government did use, it sounds like, multiple firearms that were equipped with bump fire stocks, which were basically credited with increasing his lethality. Now, if you're like me again, you questioned that, but be that as it may, that's water underneath the bridge. For those of you who may not know, bump firing, by the way, is not new. What is it? Well, it's basically a low-effort technique that you can use with many semi-automatic rifles that you can use to bump fire, whereby you can effectively achieve repeated fire, not like full automatic, but something similar to that, at least and especially to the untrained eye, where you're actuating the trigger only once per shot, but you are basically harnessing the recoil energy of the rifle to make that happen a lot more quickly. So along came something called bump fire stocks then, a little over 10 years ago, which basically, again, harnessed the same recoil energy of a rifle while shooting to allow the trigger to be pulled faster. It does not allow more than one shot per trigger pull, contrary to what you may have seen in the media. And that's going to be very important from a technical viewpoint on how this case is decided. And this is, of course, why ultimately the ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, approved bump fire stocks as not being firearms or machine guns back in 2010 when they conducted their thorough technical review and analysis. But now back to the post-Vegas fallout. So individuals on both sides of the aisle, including then President Donald Trump, basically said, look, these bump fire devices, these have to go. And that initiated a process both legislatively within Congress as well as administratively through the ATF. And on June 27th of 2018, a second review process conducted by the ATF ended finding that bump stocks, by the way, were now indeed capable of producing full automatic fire with a single pull of the trigger, the department said, and also said that the ATF concludes that they are now misclassified them back in 2010 as some bump fire stock type devices as being non-machine guns, non-firearms, and that the agency is entitled to correct its mistakes. Of course, what followed this then came up in December of 2018, where the ATF published an opinion that now, as of 2018, bump fire stocks were considered firearms, and more specifically, machine guns. This makes their mere possession a felony under federal law, as well as laws of virtually every state, if you're going to choose to follow the ATF's opinion on this. Now, this outcome has been upheld in many different courts and has been challenged in many different courts. The bans have been upheld when challenged so far, notably in the 6th Circuit Federal Court of Appeals based out of Cincinnati, the 10th Circuit Court of Appeals based out of Denver, as well as the Federal Circuit Court based in Washington. However, the New Orleans-based 5th Circuit Court of Appeals heard oral arguments in the case of Cargill v. Garland on September 13th of 2022. And they basically argued ultimately two different things that the court came down to. So let's get into the meat of the case now. The 5th Circuit decided to make their ruling en banc, E-N-B-A-N-C, And that's a little bit unusual, and it's definitely noteworthy. You see, generally speaking, Federal Circuit Court of Appeals, they have a whole bunch of different judges. Think of it like a roster. And when they make a decision or when they're hearing a case, they basically, and allegedly randomly, take a sampling of the judges within the Circuit Court of Appeals to hear that particular case. As a note, there are 11 federal circuit courts plus DC, as well as a special federal appellate court, basically to hear specialized areas of law, basically bankruptcy and things sort of like that. The number of judges per Federal Circuit Court of Appeal varies. So for instance, in the First Circuit, there are 6 judges, whereas in the Ninth Circuit out in the West Coast, there are actually 29 judges. Together, they cover 94 judicial trial districts, or judicial district courts, as they're known at the federal trial level. So again, en banc means that the entire roster of judges for that particular circuit weighs in on the case together. Not just 3, the entire group. And the reason why that's going to be really important here is because in the Fifth Circuit, we've got 16 judges. So we have 16 judges that weighed in on this. 13 of them joined the majority decision. So this was not some sort of narrow ruling or anything like that. We basically got to hear from the whole roster, and it was a decisive slam dunk. But here's the thing that you probably don't know. And you probably came here expecting to hear, okay, well, here's how Heller came into this. Here's how New York Rifle State Pistol Association came into this. Nope, not part of this case at all. Not mentioned even once in the actual decision. Instead, we basically have a decision which reached the conclusion that, nope, Cargill wins. That's the plaintiff petitioning on behalf of bump stocks in essence. And there's 2 reasons why. The first one is the fact that it was argued that they are not machine guns. A machine gun, basically by definition, by the Gun Control Act, is a firearm that fires multiple times per trigger pull. So in other words, one trigger pull can result in multiple shots. But it is not a machine gun, as you may recall, if we go by the 2010 ATF classification. So how did they reach that classification? Because again, they were relying on the Gun Control Act's classification of the fact that a machine gun is multiple shots for one activation, actuation, or pull of the trigger. Here we have in a bump stock, and again, this is the court's decision, each shot requires manual input via forward pressure from the shoulder, as well as, of course, pulling on the trigger. Since each shot requires individual input, and since each shot does not, and I should say each activation of the trigger does not result in multiple shots, therefore it fails to meet the very literal and plain reading meaning of what is a machine gun. Directly from the decision, it reads, a plain reading of the statutory language, paired with close consideration of the mechanics of a semi-automatic firearm, reveals that a bump stock is excluded from the technical definition of a machine gun set forth in the Gun Control Act and National Firearms Act. That's according to Judge Jennifer Elrod, I apologize if I mispronounced the name, who wrote for the lead majority opinion. Okay, so again, a lot happening there. So they're saying, number one, stocks cannot be prohibited, bump stocks cannot be prohibited because they are not machine guns. They don't meet the plain reading. And you know who else actually agreed with this? And this is interesting. Not a big friend of the Second Amendment, California Senator Dianne Feinstein, when they were pushing back in 2017, 2018, this quote specifically comes from 2018, she sponsored one of the bills mentioned above as far as basically trying to regulate bump stocks in Congress. And she actually opined an opinion and expressed concern about the proposed rule, which then was working through the ATF to deal with bump stocks administratively through the ATF rather than legislatively through Congress. I'm going to read her quote. Until today, the ATF has consistently stated that bump stocks could not be banned through regulation because they do not fall under the legal definition of a machine gun. Now the department has done an about-face, claiming that bump stocks do fall under the legal definition of a machine gun, and it can ban them through regulations. The fact that the ATF said as recently as April 2017 that it lacks this authority gives the gun lobby and its allies more reason to file a lawsuit to block the regulations. Unbelievably, the regulation hinges on a dubious analysis claiming that bumping the trigger is not the same as pulling it. The gun lobby and manufacturers will have a field day with this reasoning. What's more, the regulation does not ban all devices that accelerate a semi-automatic weapon's rate of fire to that of a machine gun. Both Justice Department and ATF lawyers know that legislation is the only way to ban bump stocks. The law has not changed since 1986, and it must be amended to cover bump stocks and other dangerous devices like trigger cranks. Our bill does this, the regulation does not. Again, that's not my quote, that is the quote from Senator Feinstein. You can see it in page 11 of the court's ruling. So we actually have a tacit and open recognition of the fact that, look, the ATF's efforts are going to be doomed to failure in a maybe kind of uncommon and refreshing candid analysis by a politician going on the record. So, all right, that's the one way, that's the first way that the court said, look, this doesn't work, all right? What's the second way that they got into? It's actually something that you've seen me talk about before, for those of you who are longtime viewers of this channel, the rule of lenity, Lenity. Again, Lenity. Yes, it's that important. Back to the decision, and then we're going to talk about what is the rule of lenity quickly. So the majority goes on after the first part where they say, look, this just isn't a machine gun by the plain reading. But let's just hypothetically say, you know what? It is. Well, you know what? We're still striking this down. We're still saying that it's no good because of the rule of lenity. When they note that, look, if a law is ambiguous, that is to say, if it is unclear, particularly criminal laws we're talking about here, then it is up to Congress to address the issue under the rule of lenity. So between the ATF changing their mind, going back and forth between 2010 and 2018, as well as the fact that seemingly we still have one activation of the trigger equals one shot. Not one activation of the trigger equals multiple shots, which is the standard definition of what is a machine gun. So we arrive at this place where we're basically unclear as to what's going on here, or at least the court is saying that if they're putting themselves in somebody who is in possession of a bump stock. Because on the one hand, the ATF approved, I'm sure all the marketing on the box and all that kind of stuff, and the internet writ large all said, yep, don't worry, it's not a machine gun. And then the ATF changes their mind 8 years on and says, you know what? Just kidding, it's actually a machine gun. And not because something has changed legislatively, but just because we've decided to parse some words a little bit differently and decided to arrive at this conclusion. I will note, by the way, that the rule of lenity is not some sort of modern creation. It actually dates all the way back to 1820. So the decision actually reads that a rich legal tradition supports the well-known rule, that is the rule of lenity, that penal laws are to be construed strictly. So again, criminal laws are to be constructed strictly. And I'm going to explain this. I'm going to quote from the 1820s case, so some of the wording is, 200 years old at this point, and then I'm going to put this into English for you. As Chief Justice Marshall explained long ago, the rule is founded on the tenderness of the law for the rights of individuals, and on the plain principle that the power of punishment is vested in the legislative, not in the judicial department. It is the legislature, not the court, which is to define crime and ordain its punishment. Okay, so again, plain English definition of rule of lenity: if a criminal law is unclear or ambiguous, then at a minimum, full interpretive power is to be construed in the defendant's favor. So if this is sports, this is kind of like saying tie goes to the runner, or even if you're unclear, tie goes to the runner being the defendant in any particular case, all right? So if anything is unclear as far as how a law is written, all interpretations are to be interpreted maximally to the defendant's advantage. So at the end of this case, they wound up sending it back down to the trial court, the district court where it originated from, I believe from the Western District of Texas, with directions to enter a judgment for Cargill, the plaintiff. So what's the bottom line conclusion? What's the outcomes here? Well, there's basically four things. Number one, this is a pro-Second Amendment outcome, despite me doing a Control-F search and seeing zero mentions of Heller or BRUEN. That is notable in this day and age. Number two, this is only going to be binding within the Fifth Circuit. So we're talking Mississippi, Texas, Louisiana are the only states. There's also the Canal Zone as well. But those are the only states where this is going to be lawful, okay? So if you live in another state, this becomes at best what we would call persuasive authority, which is a fancy way of saying other courts can take it into consideration. It may constitute persuasive authority and power, but it is not legally binding. Number three, check on the power of the ATF to criminalize. Again, the big thing here, as the court got into, is the fact that, look, The legislature really should be the people who are changing this, not the ATF. That power rests with Congress if we're speaking federally, especially where the ATF has actually changed their mind back and forth and flip-flopped on their position. And of course, I will just throw in this one as well. Number 4, this is a score for the rule of lenity in criminal law, something that I don't see particularly in fashion when I'm dealing with any kind of state interpretation issues, but it's nice to see that it's still scoring victories on the federal level as well. Guys, what do you think about this decision? Where do you see this going? And I also want to be emphatically clear. Look, this is going to be appealed up to the U.S. Supreme Court, so I'm not suggesting go out and purchase your bump stocks and do all that kind of stuff, at least not if you want to live life liability free. And I'm not saying that's fair. I am saying that that is the status of the law and the risk that attaches to it. But let me know, what do you think in the comment section below? Where do you think this is going to go? What do you think the U.S. Supreme Court is going to do? Are they even going to hear this decision? And basically, as well, I'm curious, what do you think about bump stocks? Are they something that's really cool and cutting edge, or are they something that, not really for everyone? Okay. I look forward to reviewing those in the comment section. And of course, again, last plug, please, please, please take a moment to subscribe, click like to show your support for the Second Amendment, and share this video around to all your friends. We'll see you next time.